Important factors you should consider when deciding between accepting severance that your employer offers you upon your termination versus filing a lawsuit against that employer for discrimination, wrongful termination, or whatever else might be relevant. Factor number one, does the amount of severance that they offer you, or does the amount of severance that you're able to negotiate represent a significant amount of money to you? 2 weeks of severance is different from 3 months, 6 months, or a year worth of severance. It's easy to say no to 2 weeks because you don't have much to lose. But it's much harder to say no to 6 months worth of severance or 12 months, especially if you're financially struggling and you cannot wait for, many months, a year or longer to get more out of a case, which you may or may not. Factor number two, how strong is your case? How strong is your potential wrongful termination case? Most employment cases are not a slam dunk, to say the least. Liability is almost always disputed by an employer. They will never come out and say, oh yeah, we discriminated against you, we wrongfully terminated you, we admit fault, we apologize, just tell us how much money you would like to get. That's just not happening. So, how likely are you to prevail in your case if you file it? That's the question you and your attorney should answer, and then balance that information against the first factor. How much money is there on the line to get the easy way through severance? If the amount of severance on the line is low and you have a strong case, then maybe it's a good idea to pursue that case, to get some justice, to get some accountability, and along with that, to get higher or significantly higher compensation. However, if the amount of severance on the line is significant and you could do something meaningful with that money and the case isn't so strong, then you should think a little bit longer and harder before giving up on that severance and deciding to sue. Factor number three, do you have the physical and emotional bandwidth to go through litigation? Many people have no problem with pursuing their civil case. No one is going to go to jail, and all you need to do is to be minimally organized, to put your documents and evidence together, and then when the time comes, tell your story to the opposing attorney at deposition or in court. But some people get really stressed out and overwhelmed by the process and by the very idea that they simply cannot help it. The very thought of answering questions or relieving the events that led to their termination raises their heart rate and blood pressure, and it might just not be worth it for them to pursue litigation, no matter how it's going to turn out. Let me give you two extreme opposite examples to illustrate this. Let's say you're an executive in finance. Your job is high stress. Your job naturally requires you to be super organized, to handle many documents, a lot of information, to multitask. So you're already naturally well-trained and good at putting documents and evidence together. And it takes a lot in terms of intimidating you with information, paperwork, questions, jogging your memory about different events. You're a person of average emotional stability or better, and you're not easily rattled by minor issues, minor frictions, or minor disputes. In this case, you don't have much to worry about when it comes to pursuing a case in court. Here's an opposite example. Let's say that you're a female who was terminated while being pregnant, and you intend to pursue a case for pregnancy discrimination. And every time you think about the events that led to your termination, you feel like crying, you're shaking, you get really upset, your heart rate goes up, your blood pressure goes up. If that's the case, at the very least, you should wait until you have a baby before you pursue your case. There is no rush in filing that case, as the law provides you with plenty of time to file that case, and a good attorney will inform you very well about all the applicable deadlines, filing deadlines in your situation. No case and no amount of money is worth risking your health, especially at such vulnerable and important stage of your life as when you're pregnant. Of course, many situations fall somewhere in between, but this is an important factor. It's every bit as important as the first two factors. Just because you cannot quantify how stressed out you get when you find yourself in these types of situations doesn't mean that it's not important. It is every bit as important. And this is the type of factor that you honestly have to ask yourself to make a decision on. An attorney doesn't know you. He can't possibly know you well enough to know how you're going to react during litigation. Most people do just fine. A good lawyer can train you, can prepare you, can help you not get worried and not get stressed out more than you should. But some people cannot control it. So you have to ask yourself that question before you pursue any type of case.